This is Laws 11057, Introduction to Law. This is week number 5, and tonight we're dealing with Chapter 8 and I believe Chapter 11 of the text. By now you've all completed, hopefully, your first assessment piece. I've marked the assessment pieces that have come in. My practice is to release those results as much as I can at the same time for all of the students, and I'll do that either on Sunday or Monday. Overall, I was very happy with the work that's been produced. So thank you very much. I appreciate that. And I can see that people have been listening to what I've said. You've looked at the sample document, and people have made a genuine and overall very good attempt to reference their material. I'm very keen on presentation. I'll speak more about that next week once I'm formally reviewing the work that's been done. Particularly for an assessment that's relatively easy, like that first assessment, sometimes you need to have a way of standing out to be noticed. And some of the work was really very good. So overall, I'm very happy. Thank you. One of the things that you will find when you start to practice in law is that the solution is not always as it would seem, that there are a number of alternatives to consider. So let's just take an easy one, and I'd like your thoughts on this. Let's say you're at a community legal centre. You're asked to give some advice to a person who has come in with a basic problem about their neighbour, and in particular about their neighbour's tree. The basic request is, I've got a problem with my neighbour's tree. What can I do about it? All right, so just off the top of your head, can anyone give me any possible solutions? Where would we go to try and sort out this problem? And what would we suggest we do about this problem? All right, so you can come in live or you can choose the chat facility. So Scott says we look at the council bylaws. Where else do we go to look, and where do we go to find a remedy? Any thoughts? Local council. So we're looking at the local council bylaws, and we're presumably asking the council to help. Noxious plant register. That's interesting, right? So again, looking at it from a local perspective, planning perspective. Case law. All right, so there might be some case law that we consider. So the client says, look, I really just want to know, what do I do about this problem? I know you're at the community legal centre, you can't help me deal with the matter, but where should I go? So, and what action should I take? So we're saying to the client, negligence, have a look at the case law, look at the noxious weed register. How is the tree affecting? Okay, so we ask some questions. Scott says, why don't you try mediation? So we're now getting some ideas coming through. So at this stage, we're referring the client to the council, we're referring the client to mediation. We're asking the QCAT, says Jesse, yep. We're asking the client to consider going to QCAT. So there are various ways that we can resolve this. And from the answers so far, I can see that we're breaking it down into a collection of asking more questions, finding out what are the material facts so that we can give a proper answer. So we need to know the material facts. From the material facts that the questions that we ask, we now know our material facts. What's the next logical thing that we need to do as far as the client is concerned? We need to identify what. So we know what the facts are. The issues. Thank you, Nick. That's exactly the word I was after. The legal issues. Thank you, Rowan. All right, so the client doesn't want us to actually do this, but this is more a mental process that we're going through in the process of providing advice. So we've asked some questions. We've now identified the legal issues. So what are the legal issues, do you think, as far as this tree dispute is concerned, in the context of providing this client with some advice? The client just wants to know, hey, what do I do tomorrow? Where do I go from here? So we need to identify the legal issues. What are the legal issues? I've got a problem with my neighbour's tree. It's annoying me. What are the legal issues? Are there any legal issues? Is it over the boundary? Is it causing damage? Boundary fences. Where is the tree? Is it on your land? Is it obstructing your view? Okay, that's great. So we've got now a selection of things that could genuinely be legal issues. Once we've identified the legal issues, whatever they might be, what's the next thing that we need to think about? We've determined what the material facts are. We've thought about the legal issues, the rules. Thank you very much. That's exactly it. The rule, the jurisdiction. So we then have to talk to the client about the rules. So we say, okay, I now understand the important facts that you're trying to tell me are these things, 1, 2, 3. From that, I can tell you that the legal issues are these. They're 1 and 2. These are the legal issues. Now, the rules that relate to these legal issues are these. So what are some of the rules, do you think? Are there any suggestions? So what are the rules that apply in relation to this tree dispute? Because the client says, well, you know, I can't go over your land. Yes, so that's a rule. Can't go over your land. That's a legal rule. Could be a tort. Yes, could be a nuisance, could be a negligent, could be a tort. Are there any other rules that we might think about in general terms? Okay, so we're starting to identify that there are some rules that apply to this legal dispute. What's the next thing we need to do then? He can't go and pull the neighbour's tree out for himself. So a bit of self-help, says Tiffany. That's always an option. Careful, though, about the help. Apply the rule to the law. Okay, A, how do we apply these rules to the legal situation? So logically in the interview, we've determined the material facts. We've said, okay, here are the legal issues. Here is the rule that applies. When we're talking about applying the facts, one way always to say it is, in your case, the words, that phrase, in your case, means that we're leading into an application of the rules as they apply in this case. What's the final thing we're looking to do? What does the client really want to know? The conclusion, thank you. So the client wants you to say, all right, so the conclusion is that at this stage, the next steps, thank you very much, here's the conclusion. So can you see that through that very simple exercise, what you need to do is train your mind to be thinking as a lawyer. Develop your thinking skills in the context of some concrete techniques. And you have to think laterally in law. So you need to think in a manner which is programmed, I suppose, with a logical flow, but you also need to think widely. You need to think laterally. And we saw that at the start. People were saying QCAT, counsel, courts. So there's a whole different way of range, you know, some self-help. So we think logically, but within the context of the broader scheme. We'll talk more about that in the course down the track. And I have a thing, and I like to call it my blue star. I'll deal with that later in the event. That's just my little code for brainstorming different options that might be available. Okay, now, does anyone know what my favourite quote out of the whole textbook is? If you remember back to week 1, you might remember this. I'll give you a hint. It's on page 267. It's my absolute favourite quote. Can anyone remember it? Page 267. You can just tell me the first 3 words. Saying cool, in a crisis. That's it? Exactly. All right, so the words that I like are, thinking like a lawyer means keeping a cool and clear head and speaking and behaving rationally when others around you may be panicking or overreacting. That's really the heart of what we need to do. When we're thinking as a lawyer, it means that you need to keep that focus, keep that clear head. This is all examinable. What are some of the ways that you can demonstrate to people that you are keeping a cool and clear head? You might find this sort of thing is on the exam. Be objective. Yes, that's a good one. We might talk more about that. Objective. Legal reasoning. Yes. Maintain focus. Look at the facts only. Don't get caught up in emotions. Thank you, Melinda. How else can you show that you're clear and in control? Think as a judge. Yes, I like that. Remain calm. Observe both sides of the argument. Thank you, Kimberly. Thank you, Nick. Don't race ahead. Yep. These are all really good points. Okay, I want you to think more about that and think about that as to what you'll do. Focus on the end game. Yes, that's great. All right, so that's keeping a cool and clear head. What about speaking and behaving rationally? Taking it one step at a time. I like that. Thank you. Duck on the pond analogy. I like that, Nick. Yes, that's a good mental thought. That's a good picture, mental picture to have. Positive body language, calm voice. Good, good. You may not have all the answers. You may not be as well prepared as you would like. You may have had a rough night the night before. There might be issues in your life that are affecting you. You need to overcome those things and perform, as it were, on the day. Now, no one mentioned acting in law. Do you think there's a bit of acting that goes on? Remain professional. Are we actors, really? Yep, I think we are. I think actors would make good lawyers. Fake it till you make it. Yep, that's it. You don't want to be arrogant about it. You want to make sure that you're professional at all times. But there's a bit of acting. Act like you know exactly what's going on at all times. Yep. Be prepared to concede issues or mistakes at the appropriate time, but remain in control, remain calm. I really want you to think about these issues in your context. And you need, in order to think like a lawyer and act as a lawyer so that you are behaving rationally when others are panicking or overreacting, it seems to me that you need to know yourself. Some people have weaknesses that will get in the way of them being able to act like a lawyer or think like a lawyer. So without becoming too personal about it, you need to think about that. Scott says, understand your limitations. Exactly. So you need to identify where you may have issues so that you can perform at your best. This is all examinable stuff. So it's almost like doing a SWOT analysis, isn't it? And as I've said in the past on many occasions, thinking like a lawyer often means thinking about the end result. What do I want to achieve? And then think back, what do I need logically to get there? So if you were asked how you will think like a lawyer in a stressful situation, you need to be able to come up with some answers as to your strategy for dealing with that. Now, there was one word, objective, which I really liked at the start. I forget who said that, Nick or Scott perhaps, but what does that mean? Tell me what is meant by objective and what's the contrast to objective? What do we mean? Objective, withhold, right, so the contrast is subjective and objective means withholding your personal perspective, looking from the outside in, being impartial, okay, all of those things. So in the material, in my being impartial, yep, so being objective is looking at it as a reasonable person. I like those words. Reasonable person goes well with the word objective. It means what would a reasonable person in these circumstances think as a result of viewing what's happening. It doesn't necessarily mean what the party in question thinks. That's subjective. Being an outsider looking in. Yep, that's it, Nick. I like that. So understand what we mean by objective, understand what we mean by subjective, and think about how you can be a lawyer and keep that cool and clear head that I want you to do. All right, now I take it that you've all read about the legal logic. We've done a little demonstration of that tonight. We've considered the IRAC method. There are a few different acronyms. IRAC, issue, rule, application, conclusion. Can anyone give me a couple of other acronyms to what mean essentially the same thing as IRAC? CIRAC, HIRAC, MIRA-T. I don't know what that one is, so you'll have to tell us about that one, Diana. IREC. All right, so the two others that I've written down on my sheet are MIRAC, M-I-R-A-C, we've got CREAC is coming through, C-R-E-A-C. I like MIRAC, Material Facts, Issues, Rules, Application, Conclusion, same as IRAC with an M in front. CIRAC is where you state your conclusion first, and then issue, rule, application, and conclusion. So Diane says the material facts, issues, rules, arguments, tentative conclusion. That's very good. Okay. Can anyone tell me what hierarch means? Or CREAC, C-R-E-A-C. Can someone expand on that? Because I'm not familiar with it. Oh, Nick says heading and then hierarch. Okay. It's on page 267, says Emma. Have a look at my textbook and then I'll find out. Oh, there it is. CREAC, conclusion rule, explanation of rule, application of rule, and conclusion. Thank you very much for that. I didn't look very far, did I? It's on my textbook, or our textbook. Thank you for that. So the point of that is, I'm not going to ask you a question of giving me 5 different acronyms that talk about the process of legal reasoning. What I want you to do is adopt one or more of those and then tell me about the strategies that you will adopt, bearing in mind your own strengths and weaknesses, in implementing these types of things in a real life situation. So tonight we've talked about you potentially being on the spot, being asked a question about a tree dispute, about as simple as they come from a legal point of view. And have I ever lost it in a case? Oh no, but my opponents have. But no, I don't. One thing I do is I do use the CIRAC approach a bit. So for example, today I was making submissions in relation to a person who really did have to go to jail, and my opening submission was the conclusion, and that is that it is conceded that imprisonment is the only form of appropriate punishment, but I do submit, and I will submit, for this type of imprisonment and a structure for the sentence. And having said that, right from the start, in this case the magistrate knew where I was going with it. I then went through that process of logical reasoning and arguing to then come back to that point, which is basically to say, so the reason that I, from the outset, made this submission is for these points. So sometimes stating the conclusion at the start, particularly in a submission, is useful because then the magistrate understands where you're trying to get, what you're trying to achieve, and can follow, hopefully, your logic in doing that. Okay, so no one's left guessing. Yes. So, you know, when you're taking instructions from a client, sometimes it can be very frustrating because you know your client has a problem, but your client won't tell you what the problem is. They won't tell you what you're asked to do. And if you know from the outset, or if you can extract from the client from the outset that they're here to get some advice in relation to a potential issue, or they're here to go to court, or they're here to explore options, it's really helpful because you can then put everything in context. Okay, so thank you very much for all of that. So do need to think about those processes. The answers that you've been giving through Moodle in relation to the problems have been very good. And in particular, the questions that are, or the examples in the text, I think are very good in terms of trying to identify the material facts. All right, so let's have a look at page 270. And I think this was one of the tests that we had on the way through. No. Is CIRAC, are they, the two C's are the same in CIRAC? I think they are. Yeah, it's not on the sheet, is it, CIRAC? It's one that I use. Oh, yes. Down the bottom it says conclusion, conclusion. Yeah, the two conclusions are the same. And it's pretty much what I did in that submission today. From the outset, I say, this is what I submit is the appropriate conclusion. I then go through the discussion and come back to that first conclusion, essentially repeating it. Okay, so let's have a look at the exercise on page 269. And I'm just going to ask you to tell me briefly what are the important things in the problem involving Gaia and Kevin? So can I just have some words, please? What's important about this? Okay, so is it important that Gaia is, right, duty of care? Yeah, sorry, I should explain. I'm just after the facts at this stage. What are the material facts? What's important on this? Is it important that she went to see her local, all right, that she was at a bar? Yes, that's important. Was it important that she went to see her local band? No, that she was injured. That's important as well. So she was at a bar and she was injured. That's important. That she was a patron. Yes, that's important as well. That Jay stage dived. That's important. Yep, I agree with all that. The phone was damaged. Yep. That Kevin owns the bar. That's important as well. That Silent Bob didn't do anything. Yes. So a material fact sometimes can be a failure to act. So these are all important material facts. I agree with all that. The employer allowed him to stage dive. That's important as well. Okay, so I think we're getting a feel for it. Now, can I just get a quick poll? Can you tell me, just raise your hands if this was the case, did you, when you're doing that, do you use a yellow highlighter or some sort of highlighter? I do. Yes. Yep. Yep. All right. Or underline. Everyone's raising their hand. All right. I think it's an important way to do it. And those that wanted to resell their book didn't. And I can appreciate that. I can go with that one as well. All right. So that's what's important. And I think you all did very well in terms of identifying what was important at the supermarket. So on page 270, we have the simple legal problem. And I put down there that it was relevant that Catherine was shopping at a supermarket, that Catherine selected the avocado, she squeezed it gently and placed it in her basket. I thought that was relevant. I thought it was also relevant that she attempted to return the avocado and is stopped by the store manager. So that's what I thought was relevant. Did anyone have anything else that they thought was relevant in that exercise? This is the exercise in the think box. That she hadn't gotten to the register, yes? Yeah? Yep. That can be relevant. I put in as not relevant that it was a Saturday morning, that they were on sale, that she was cooking Mexican, that she bought some corn chips, that she left and returned to the fruit and veg section, and that she had 3 avocados in her home. All right, so they're the important material facts. The next thing we've got to do is, of course, identify the legal rules. So in that, so Diane is sort of moving into the legal rules. So what are the legal issues? All right, so we've determined what the material facts are in that case. What are the legal issues? Legal issues. So Catherine has been shopping. Intent. No, a bit more general than that. I'm looking for more general words. What are the legal issues? Contract law, yes, I like that. What is the point of sale? Is it an offer versus invitation to treat? When is the contract done? Yep, this is all good. Good. And intent is good too. So when is the contract done? So for those that haven't studied contract law or not studying contract law at the moment, there is a difference between an offer and an invitation to treat. An invitation to treat is really where a person is suggesting that they're open to offers to be made. So if you go into a display in a supermarket and Tim Tams are on special, $2, bargain, that sign is actually an invitation to treat. It's not an offer to sell you the items for $2, the Tim Tams for $2. When you go to the register and you present that item, you're actually offering to buy it, and the acceptance is when they ring it up on the till. Does anyone disagree with that analysis? Okay, so the process of advertising is what we call the invitation to treat, and it's kind of putting up a sign, we're open for business, we're open to offers being made. On one occasion, my wife wanted to buy a watch. There were a whole lot of them in the counter. One was much cheaper than the others. They were all identical. She wanted that one. The shopkeeper came back and said, sorry, it's a mistake. It's actually the same price as the others. And there was a little mini argument about what's an offer and what's an invitation to treat. So I just stayed silent. Yeah, we don't tend to barter at the point of sale. That's true. Pharmaceutical societies against Boots, cash chemist. Thank you, Scott. That's the case. All right, let's talk about deductive reasoning. We'll move on. Did anyone have difficulty with this area? Deductive reasoning, inductive reasoning, reasoning by analogy, faulty reasoning. Did we all find it easy? Yes, no. Well, easy. Who found it easy? Yes? Yes, yes, yes. Who found it not so easy? A couple of light bulb moments. I actually found it tough. I find it, reducing it to a page, I thought was tough. With these things, I want you to think about them. I want you to apply them. I'm not going to give you a question that says, explain to me what is meant by deductive reasoning. But what I do want to see, I want to see it in practice. You can always describe it. You can say something, reasoning by analogy. My reasoning is that this is the case. You can always add that into an answer, but you won't be getting a question per se on what is meant by deductive reasoning or inductive reasoning. I want you to see that in practice. All right, so deductive reasoning, just in simple terms, if we have a situation where we say all x's are y, this is kind of the format. So all x's are y, this z is x, therefore x equals y. So the premise follows the conclusion. Yep. So, all dogs are mammals. This animal is a dog, therefore this animal is a mammal. And before, I think I should have said, therefore z equals y, not x equals y. Okay, so I told you I didn't find this easy. The premises has to be true to be valid. Thank you, Dinah. Any other comments about deductive reasoning? All right, so inductive reasoning is a little different. It's essentially a prediction based on past experience. We need to be careful because one of the faulty reasonings outlined looks a little bit like inductive reasoning, but we'll get to that shortly. The premises have to be true for the conclusion to be valid. Yes, thank you, Eustace. Confirmation bias. Okay. Reasoning by analogy. Because a certain thing is similar to another, then reasoning by analogy suggests that one will have the characteristics of another. You need to be careful here because this can easily become faulty reasoning, either reverse accident or hasty generalization. Can anyone see why reasoning by analogy could become a hasty generalization or vice versa? Broad assumptions, yes. And this is where I don't like to examine this because to my mind there are just too many grey areas. Sure, take it in, all Kiwis play rugby, yes. I hate generalizations, predict, yep. Yeah, you do need to be careful with the generalizations. All right, faulty reasoning. Sweeping generalizations. If the main premise is overstated, then conclusions will be invalid. And I think that's right, just going too far with the generalizations. Hasty generalization, generally there's just not enough evidence, and that's why I was concerned about it being confused with reasoning by analogy. Maybe there's just not enough evidence there to support what you're saying. Attacking the person, just because a person is bad or has a trait or characteristic, that does not necessarily mean that a bad person will always have that trait or characteristic. One politician may be seen as doing the wrong thing. That does not mean, therefore, that all politicians are doing the wrong thing. Attacking the person, we did that. Appeal to authority. Look, it's okay to question what's said. Bad example, sorry. It's okay in law to question. You're almost duty bound to question. If you don't question, then you are not necessarily doing your job. A particular case might be decided 4-3 in the High Court. So 3 people were not prepared to go with what the other 4 said. That's okay. That's the way that it works. Appeal to majority, just because most think a certain thing, that doesn't make it so. Straw man argument, misrepresentation or exaggerating the opponent's position. Irrational correlation and causation. During the last 100 years, we've seen less pirates, but more global warming. Therefore, global warming is caused by a reduction in the number of pirates. I don't think so. Okay, so have a look at that for yourself. Critical thinking. In order to be a critical thinker, sounds good though. In order to be a critical thinker, you must be reasonable. Criticism, not just simple criticism, but informed criticism is what we're after. You have to ask yourself, is my argument reasonable? And ask yourself, if you're promoting an argument, let's say in court, have you based your argument on reliable information and a valid assumption? So this is where the reasoning comes into effect. Not criticising. Yep. Do your arguments contain validity? Is it consistent with primary sources of law? I want you to keep going back to those primary sources of law. Get to know your Ostley, ComLaw, get to know your court's website. Go in and have a look at the legislation. Can your argument be supported objectively? Yeah, we don't want to agree without questioning. Can your argument be supported on the basis of fairness and justice? And at page 289, the authors say, critical thinking is an act of thoughtful disobedience rather than thoughtlessness or automatic disobedience. And I really like that quote. So critical thinking is an act of thoughtful disobedience. What a great thing it is to have a law degree and having a license to argue and question. It's important, and you have a responsibility to follow through on that. Okay, thinking skills, page 290. Interpretation. Well, we've done a lot of that. When you commence this course, did you think that thinking skills would be as relevant as they are? You need to determine that's good. You need to determine the material facts, and you need to undertake the process of analysis, evaluation, inference, explanation, and self-regulation. So these are the skills. You can see those skills listed on page 284. You're not going to get a question about telling me that list. What I want to know through your answers that you give me in the examination is, can you put these into action? Now, your blog, if you think about it, is a perfect way to go about showing me that you have those skills that are mentioned there. Because I'm asking you to think about how these things affect you and others in real terms, in practice. Then we have the attributes of a lawyer. And you might think it would be examinable for me to ask you, to tell me some ways that you can improve your skills in relation to the named attributes. You need to be honest a bit, and I'm not asking to be, personal information, but if you look at that list on page 296 rather, of the attributes that you need as a legal practitioner, it seems to me that you need to just don't read it and gloss over it. I don't like dot points, because you look at that list and you say, oh, yeah, that's a bunch of dot points. You don't think about it. You don't think it through. But I'm asking you to think about that. I've put a big asterisk next to this. So how are you going to demonstrate to me, if asked during the exam about your attributes, that you have thought about ways to improve your skills in relation to flexibility? Okay, so a lawyer, you need to be flexible. Well, tell me how. How are you going to improve your skills regarding flexibility? How it started yoga? Yes, that's a very practical way in both senses of the word, to be flexible. How are you going to improve your skills in terms of persistence? Don't just tell me to be a lawyer. To be a good lawyer, you need to be persistent. Yeah. But how? How are you going to become more persistent? You're going to look at both sides of the argument, okay? So you're going to train yourself to do that. You're going to be aware of case law so that you have more options. You won't be satisfied with the mediocre. You're prepared to get to the bottom of a matter. That's how. Don't give up. Yep. So I want you to think about those things on page 296 and be able to tell me how you are going to be a person who improves the attributes of a lawyer, and be ready to tell me in an exam situation. And you might think, what might surprise you about this course is you might say, well, I thought we were going to be learning more about the law. Look, remember right at the start, those things that you need to consider as being a lawyer? Knowing the law was one of them, wasn't it? There's a whole lot more to it than that. Knowing it's important, but it's not the be-all and end-all. And remember those statistics that we talked about mental health and lawyers? That's why it's important that you have these game plans organised. All right, creative thinking. You need to be a creative thinker. Practicing in law should appeal to those that do have creative minds. Creative minds should not just be in the School of Fine Arts. Creative minds need to be in law school as well. You need to be creative. Throughout this course, we've already talked about brainstorming. We've talked about generating options. We've talked about thinking laterally and analytically, but also broadly. You need to be creative in the way you come up with possible solutions. So I'm going to ask this question of you. It's all examinable. How can you develop better skills in terms of being creative? And you've now got to think about how creativity in law is improved. I will give one answer, and that is taking the use of mind-altering drugs is not an acceptable answer to being a more creative lawyer. All right, so we've got to think of other ways to do that. Think out of the box. Yes, I like that. How are you, if asked in an exam, how are you going to become a more creative lawyer? What are you going to do? Research? Yes. Thinking out of the box, research. What else are we going to do? Here's your chance to think about how you can help your fellow students explore all possible alternatives. Talk to colleagues, diversify, ask more questions. I like that. What else can you do to be more creative? Nobody's mentioned technology. Isn't my challenge to you that I'm a better typist to you because I've been more creative by using voice recognition? Talk to a broad range of people. Yes? These are all good answers. Step back from the problem. Okay, just take a different perspective. That's a good creative way to do it. Okay, so think about that issue. Thank you. All right, we're almost at the end of what I want to do tonight. I know I've just started on chapter 11, so I'll be quick. Look at both sides of the argument. What if you're wrong? Yes, that's a really good creative way to do things. That might be part of your technique. You might develop a little checklist for yourselves. What if the women are never wrong? And when I say creative, I mean creative in a logical sense. Remember keys in the fridge? That's part of what I do. That was a bit creative, don't you think? Having some practical way to deal with issues. Looking at the start, thinking, okay, on Monday morning, I need to be at court. What do I need to do a good job at court? And thinking back, isn't that process being creative? You're coming up with ideas, you're coming up with logical steps. All right, so these are all things that you need to think about for the exam. Judicial activism is referred to on page 384 to 386. And this is where a judge, or more likely a number of judges in the High Court, will reform the law. And judicial activism is really where the law is unjust or obsolete or defective. And judges do this generally through common law, but Kirby comes to mind, yes, absolutely. So judicial activism is more than just creating law through precedent. This is really turning the law upside down. Mabo is the prime example of that, where it was the High Court that essentially created the existence of native title. That wasn't done through Parliament. It was essentially ratified by Parliament, but that whole legal concept was created through a brave act of judicial activism. Does not go against the separation of powers. I'm really glad you raised that, Jonathan, because you know that you will have a question on separation of powers in the exam, and you might raise that as an issue. You might say, well, here isn't the law blurred? Isn't it Parliament that is supposed to implement policy through creating new laws? Have the courts got that role to do that? Judicial activism against the Carmody appointment? Yeah, maybe, not so sure about that. So judicial activism is something that you might need to consider within that context of who's supposed to be doing what around here, and is this okay? Critics might say that judicial activism works retrospectively. Critics might say that judges are second-rate lawmakers. It offends against the principle of separation of powers. That's what critics of judicial activism might say. Proponents of judicial activism might say politicians are too worried about getting votes, and sometimes you need the High Court to come in and say, this is right, this is just, this is what it should be. All right, so part of your homework is think about some of those issues that we've talked about tonight. Is it really a separation, says Jonathan? Yep, so just question. Look ahead. Looking ahead to week 10, I know I'm a long way off now. I want you to have a look at problem number 33 and think about it progressively as we go. Diana says, when the court is asked to determine they must respond, they don't go out of their way. All right, so question 33 is, consider the Australian Guide to Legal Citation as a guide to your fellow students. What are your 3 top tips? Students, practitioners, we all find the Australian Guide to Legal Citation difficult. It's long. So I just want you to start thinking about what are your 3 top tips, and I would like everyone in the class to provide some answers. And I don't mind if you have a few answers at this. If you come in this week and provide an answer to problem 33 in week 10, and then you decide later that you've got some better tips, well, just go in and give us another answer. All right, so I want to see lots of people exchanging ideas and views on how you can use the Australian Guide to Legal Citations. Also, I'd like you to complete your reading, think about chapters 9 and 10, and start thinking about how you would practice as a lawyer. How would you interview clients in UCRU, John? No, we might do that one, Megan, through Moodle. If we could put the answers there in the problem 33, just add it as an activity in problem 33. So most of you have been answering those problems each week. Thank you very much for doing that. And that's why we might do that one. All right, so for next week, start thinking about how you'll practice in lawyer. How will you interview clients in the courtroom, your legal writing skills, your ability to collaborate, and also how would you cope with the demands of legal practice, think about mental health and resilience. So there's some exercises for next week. How many words are the questions in the exam? So there's no word limit in the exam. You just write as little or as much as you like. I'm telegraphing some of what the exam questions will be. So you can start to prepare your actual exam answer now, and you can take the exam answer in with you. It's not like it used to be in the 70s. You can write the answer. If you think you've got your answer for separation of powers or resilience or the way in which you can improve your skills and attributes as a legal practitioner, you can write all your answers now. Take them in with you. Okay. All right. So are there any questions before we stop for tonight's session? Thank you very much for your patience. You've been all very good, very active. How open book is open book? I've got a big old folder of notes here. I don't mind if you want to take in a trolley with all your notes and answers and books. That's fine by me. You can't take in anything which will connect you to the internet, and for some reason you can't take in a standard dictionary. You can take in a law dictionary, but not a standard dictionary. So you can't take anything that will connect you to the internet, but you can take in this whatever. iPads are out. Can't take iPads in. Problem is that if you've got ebooks, you can't access them in the exam. Sorry. So you need to work out something to do there. All right. Any other questions about the exam? It doesn't connect. I still don't think you're allowed to take in. I think they'll stop you if you take something in that they think can connect. So just be careful with that. Just check that out with the exams. I'm not at the exam. I just get the exam papers later. Okay, thank you very much, everyone. Next week, we have a week break, yes? So we won't be meeting this time next week. It will be 2 weeks before we meet again. Okay. All right, and I'll get you some results next week. All the best. I'll stop the recording now. Thank you very much.